with the lawyers. First, we appreciate your and your client's agreement to participate by Zoom in these oral arguments. Being able to do this has allowed the court to continue its work for the people of the state of Tennessee and your client, of course, including your clients. If we should have a technical problem of any kind, don't worry about it. We'll simply pause and work through it. We haven't had one for a while, thanks to the fine work done by the IT staff in Mr. Hibner's office. But if we do, we'll pause and work it out. Call the case, please.
In re Alexis S.
We'll hear from the appellant.
Thank you, Your Honor. My name is Crystal Jesse. I'm from the Greene County Bar. I am arguing on behalf of the appellants, Mr. and Mrs. King. I would like to reserve 5 minutes for rebuttal, please.
That'll be fine.
We were previously before this court on this matter last fall, and the court put down an order dated October 29, 2019, and remanded the issue to the trial court for specific findings. I'm going to quote directly from your order, starting on page 1, section 1. The appellate court stated, because the trial court failed to make sufficient findings as mandated by 36-1-113K, we reverse the trial court's determination that the ground of abandonment by willful failure to support the child was established and remand the issue for the trial court to make requisite findings and enter a judgment accordingly. Therefore, based upon the first page in the clear language of the opinion, the remand was for abandonment for willful failure to pay. I go on to read directly from page 15 under the section for abandonment failure to visit. This court stated, due to the trial court's failure to make specific findings of fact regarding the mother's visits during the relevant 4-month period, we are left to wonder what facts form the basis of its conclusion that she abandoned the child for failure to visit. The court then goes on to state, therefore, we will determine whether another ground for termination has been proven by clear and convincing evidence. If so, we will review the trial court's determination that termination of the mother's parental rights is in the child's best interest. If not, we then must remand the trial to the trial court to make specific findings of facts and conclusions of law. So in that section, we see if so, if not. We go on to page 18 under the separate issue of G14 that is titled, and it's section C, ability, willingness, and risk of harm. In that section, in the body of that section, this court says, we remand the petitioner's claim that the mother abandoned the child by willful failing to visit during the 4-month period before the petition was filed, the instructions for the trial court to make specific findings of facts and conclusions of law. The court goes on to order the trial court to do it within 60 days. I've taken the time this morning to review that because perhaps I am wrong. I've reviewed my brief versus opposing counsel's brief, and it appears we're arguing apples versus oranges. Opposing counsel alludes that the only issue on remand was failure to visit. However, as I pointed out specifically in my brief on page 1 of the trial court's order, it is clear that on remand, the trial court was to address the findings of fact and conclusions as to failure to pay child support and support the child. Furthermore, the issues before the court, and I don't know if you have the 1-page order that I'm holding up, dated February 5th, 2020, the trial court did nothing the Court of Appeals asked it to do. First, the trial court did not make the findings within 60 days. Opposing counsel and I had to reach out to the court in January asking if there would be an additional hearing or if an order would be forthcoming. The order was forthcoming February 5th, 2020. As you can see from the order, the trial court made no findings whatsoever for either issues remanded. Specifically, the trial court did not address at all the willful failure to pay and support for the child. Is not even mentioned in the 1-page order. What the trial court did in paragraph 1, it addressed willful failure to visit, but it solely reiterated exactly what it said in the previous order that was before the court that was sent back. It made a conclusion of law. The judge simply stated that the facts rose to a preponderance of evidence, but did not rise to clear and convincing evidence. Based upon that, the court should have, based upon your order and directive, made additional findings as to why it even believed it rose to a preponderance of the evidence. But as I stated in my brief, the trial court did nothing. There's not a single finding in the order. More importantly, one of the final arguments that opposing counsel and I agree upon is that in the second paragraph of the order, the trial court then takes it on its own accord to reverse the termination of the father, Mr. Shawn, without any direction to do that. The court didn't remand it for him to take up any issues as to Mr. Shawn. And the specific language of the order states the court further sets aside the termination of the father's parental rights because the father consented to the termination based upon the parents being able to adopt the minor child. The problem with that paragraph, if you read the technical record, and as I pointed out in my brief, the father has yet to come forward to withdraw his consent. Of course, he can at any point in time before the adoption takes place. But what's even more concerning is that from the technical record, the trial court terminated his parental rights based upon Miss Vanessa Thornhill's intervening petition. The Court of Appeals upheld that termination because the father did not argue it. The trial court and the Court of Appeals upheld the guardianship that was granted to my client. Even if the Court of Appeals would have simply reversed, my clients would have still been entitled, as they were the only one that pled for guardianship at the trial level, for at least partial guardianship. So the issue as to paragraph 2, which opposing counsel and I agree upon, the court didn't have jurisdiction to do that. And fundamentally, if any issue was going to be taken up as to the guardianship that was vested in Mr. and Mrs. King, we had a due process right to further hearings on the matter, which we were not given.
Counsel, before you get, before your time expires here, let's go back to the willful failure to pay child support. Did the court, it's my understanding that when we sent this case back on remand, we specifically reversed the court's finding on that and did not send it back for remand on the failure to pay. Am I wrong about that?
I think you are. I'm sorry, there was an echo there.
Yeah, go ahead.
The very first page that I quoted specifically says you are remanding for further findings as to willful abandonment for failure to pay. It is absolutely on the first page of the order, and by the plain reading, then the remand would have been for both grounds.
Okay, so you, that's your position. So on this appeal, your issues that are presented to this court are based upon what? Failure to pay and failure to visit?
Yes, Your Honor, failure to pay and failure to visit. And perhaps I was wrong. I did not clearly set out the failure to visit. However, I am relying upon N. Ray Carrington, because as opposing counsel pointed out, if I made the mistake and did not address failure to visit, the Supreme Court's ruling in N. Ray Carrington H says that the Court of Appeals has to take up every single ground alleged. So the two grounds alleged that were supposedly sent back, and if I missed the failure to visit, which opposing counsel says I did, the Court of Appeals still has to take it up and go through the findings and the substantive issues of it based upon N. Ray Carrington.
Did the Supreme say that we have to take it up if it's a ground, if it's found to be grounds for termination, or just if any ground is alleged, even if the trial court finds it's not grounds for termination, we have to consider it?
I think you have to consider every single ground alleged.
Even if the trial court found the ground wasn't proven?
Yes, I think a Court of Appeals has to go through every single ground and findings as to every single ground, because the Supreme Court said it's a fundamental due process right. And if somebody makes a mistake, like perhaps I did in reading the order, that we do not want any parent to not have their due process rights. So any ground alleged that was
No,
before.
but if the trial court finds that the ground isn't proven, parent won't have their due process rights violated, will they?
Yes, I think they absolutely would, because the court didn't.
If the trial court finds in their favor,
I think it's a fundamental right vested to the child too, and to all parties, because we're
well, is
here.
that what the Supreme Court said, or were they just talking about the fundamental right of the parents? And that's why they instructed us to address, I thought, and we'll look at it again, only those grounds found for termination.
I will double check that as well, but if we apply that, I absolutely will. But if we apply that, the trial court still didn't do what you told him to do. He made a legal conclusion, and once he makes the legal conclusion, he has to find the findings of fact to support that legal conclusion, and he didn't do that. Thank you.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellate.
Thank you, and may it please the court. I'm Aaron Chapman of the Hamlin County Bar, and I also want to commend your staff and specifically your clerk for how they've handled this unprecedented time for the courts. We've been kept in the loop the whole way on how to properly present these cases, argue these cases, and it's been a very rewarding experience to work through one of these challenges, if you can believe that. So I do think that I will address the appellant's arguments that page 1 of the appellate opinion from last October somehow ordered that the case was to be remanded to determine the issue of willful failure to support. That's in the syllabus of the case. The opinion of the case is titled to begin, page 2, opinion, and that is what's authoritative. I've searched when I briefed, I've searched this morning, I searched yesterday. I find no authority for in any Tennessee case that the syllabus of the opinion is the court's opinion. It's a descriptor. It's a descriptor, and somehow, I mean, I stipulate here, I've got it redlined on mine too, that it says willful failure to support. The issue with that is completely blown away when you read the opinion, which is very thorough and replete, that the only issue for remand is to determine what facts exist to the clear and convincing evidentiary standard that would support a finding that mother willfully failed to visit in the 4 months before the petition was filed. So this is really a matter of if we're relying on the syllabus. Well, the syllabus doesn't reference, I don't think the syllabus even references this going back on willful failure to visit. So it's clearly an issue of support being interchanged with visit on the syllabus, which is not a binding portion of this opinion. There's no authority for that. Yes.
Counsel, let me point out to you that the syllabus is done by the court. It's not done by Westlaw or any of those people where I think the type of syllabus you're talking about, that initial paragraph is prepared by the court. So it's not a syllabus prepared by someone else. It's actually part of the court's opinion, as I understand it.
Well, at that, if you review the entire opinion, it never makes mention of this being remanded on the issue of support again. In fact, it says that issue is dispensed with. And I mean, it's very clear, as we've argued, this has been established by this court. The specific findings were made, they were overturned, and the issue of support is no longer on the table in this matter pursuant to the law of the case. We are here on the issue of a willful failure to visit being alleged. And in that regard, we believe that the appellant's case is fatally flawed because it did not even reference the visitation. I mean, had the opinion actually been referenced here and read and reviewed and argued that in that context, we'd have a different argument. But That's not where we're at today. We have a brief based entirely on an allegation that the court did not do its job with regard to support when that's completely been ruled over a year ago. So we believe the brief is fatally flawed. We did respond to those arguments with the law of the case doctrine. I cannot see how this case survives the law of the case. There are factors in the law of the case doctrine that say, well, this is how you get around it if you want to use it. And those haven't been pled. I believe the appellant had an opportunity to reply to this argument when served with the brief. That was not done. This is the first time today we're hearing that there might have been some confusion about what would have happened at the, with the interchanging of failure to visit and failure to support. But the factors you're going to look at on the law of the case to get around it, if that's what appellants are seeking to do, would be that the evidence offered at the trial was substantially, or the remand was substantially different from the evidence in the initial proceeding. That's inapplicable here because we use the same record. 2, the prior ruling was clearly erroneous and result in a manifest injustice if allowed to stand. That's not been alleged here. That in fact, insofar as appellant's argument addresses the 4-month issue, that the issue of which 4-month period to apply, not only did this court last year use the right standard in citing the developing law around that issue at that time, but this opinion itself, Alexis S of 2019, has been cited 3 times this year to support that same contention. So the court was using the correct law then and has indeed said, well, now this is correct law to use future on this issue in the future. So that's not something that would support a clearly erroneous decision. And 3, the prior decision is contrary to a change in the controlling law which has occurred between the first and second appeal. Same argument there. This is not contrary. It has indeed become really part of the common law on this issue. So I can't see how there's any way to get around the law of the case doctrine applying on that failure to support issue and on that 4-month issue being sustained. So that's our position on that. What you do have in the order is you have what amounts to a very vapid order on the facts. I agree with that, but what you have here, as Judge Sweeney pointed out, was that this is something that would have given, where we invoke the due process on trying to thoroughly articulate the reasons that we use to terminate rights, we may not rise to that level when those facts are not found. So we do believe that the court was stuck in a situation of having to re-articulate that the trial court did not find those facts had been established to the clear and convincing evidentiary standard. And what that's an indication is there's an inference that those facts aren't there. Those facts aren't there. And so what we're left with is the appellant has the duty now to bring out what facts were there that would support that. And no facts have been addressed on that issue either. The facts aren't there. There are no facts to support any finding that the mother willfully failed to visit by a clear and convincing evidentiary standard. And so the court has not referenced the facts because they're just not there. Now, this court has the authority under Rule 13 to look at the entire record and find the facts that were established in evidence and make a ruling from that. And you're going to find that. You're going to find, we've argued those facts were there. The mother testified. She visited every time that she could in that 4 months. She visited every time that child was there with her mother. They lived in the same home during part of that proceeding. Child's going over to her house. She's got parenting time with that child. So that had been established, and it was so clearly established on direct and on cross that the court said, well, there's not facts. And that's what the court did in this it's a light order, but that's what the court did in the February order. So, but again, we contend that that issue would be fatally flawed because it's not been briefed. Rule 13 presents that if an appellant has an issue to brief and present for review, they need to brief that. So that's the gist of our argument on that issue. It is true. I think we did kind of coalesce around the idea that maybe the court exceeded its scope of of review in overturning the termination of the father's parental rights. And we stipulated that. It sounds today like we got there on different reasons. The reason we argue that is that's beyond the scope of the remand. It's the same issue. It's very similar to the other grounds alleged by the appellant. It's beyond the scope of the remand. The court shouldn't have taken it up. We've stipulated to that. So that's where that comes from. It wasn't an issue of whose termination that came in on and who was guardian. And it's not that complex. That is really overthinking that issue. The court remanded this on one issue, and then the trial court came back and overturned another issue. That's beyond the scope of remand. That's clearly erroneous to do that. So that's why we stipulate to that. But in getting back to our arguments, the arguments presented in the appellant's brief are entirely precluded by the law of the case. It sounds like there's an effort to borrow some of that reasoning from an argument on an issue that was not an issue at the remand to support an issue that was actually remanded. That's not what we would see to be in comport of presenting the issues under Rule 13 of the Rules of Appellate Procedure. So that's our position on this case. We believe that the court, if the court entered a bad order, it is imperative on an appellant who's appealing a bad order to say what actually makes that order bad. And that's not even the issue that we got to here. We got to an entire issue that if you read this, if you read this 24-page opinion from last October, you see that the court was clearly remanding this on the issue of willfully failing to visit and not in any regard to willfully failing to support. That was completely blown over and, in the words of the opinion, was dispensed with. So we think the appeal is fatally flawed and should be dismissed. And I would yield my time back unless there are questions.
I hear none. So we'll hear from the appellant rebuttal.
Thank you, Your Honor. Again, I would say that the order is clear on the front page as to what was remanded, and it was failure to willfully support the child. That's what it was brought up. The second issue I'd like to address is I don't think we waived the issue on failure to visit, as opposing counsel specifically said in his brief on page 23 that I did present some overlapping issues as to failure to visit and failure to support. I would have brought this up sooner, except for it was just noticed this week by myself as to the differences in the opinions versus briefs prepping for this. But as he said in his own brief, I did bring it up in overlapping issues. But regardless, the trial court didn't do what you told him to do. He was sent back to find further findings. Once he made that legal conclusion of preponderance of evidence, he had to put down some sort of findings, and he did not do that. What's even more concerning is what led him to that. If you pull the technical record, you will notice that I filed a motion to combine the two cases at the Court of Appeals. The technical record from the first appeal never came back to the trial court. The transcript didn't come back, neither did the evidence. So there's no indication other than memory as to what this court based its opinion on, which is concerning, which brings up one argument in my brief that opposing counsel did not argue here today and has not argued in his brief, was my request for a new trial based upon In re MEI, or that this court make its own substantive findings based upon White versus Moody, because this case has been pending since 2017. The memory of a court to put down a one-page order is all that we're going on, with no findings and no indication that any of the record came back. So I would specifically ask that if we are remanded on a full trial on the issues that are left to be presented, which I would submit would be findings as to failure to pay and failure to visit, or based upon White versus Moody, in the interest of justice, for this court to make its own substantive findings. One issue I do want to bring up as to my argument as to the other 4-month period, I brought it up to preserve it for appellate purposes. Alexis S was the first case to come in front of you as under the new statute with the 4-month period. I have not found a case that has asked for cert on the new statute to the Supreme Court, and we've not had a final order to do that. So I was not going to waive that argument for further appellate purposes. I understand this court's opinion, and this court's opinion has been very repeated, as Mr. Chapman said 3 other times, but I did not want to waive that if there's going to be further appeals. With that being said, do your honors have any further questions today?
I have none. Thank you.
I hear none then. Thanks to counsel for both sides for your briefs and your oral argument today. If you would please, Madam Clerk, recess court until 11 o'clock.
This court is in recess until 11 a.m.
Thank you.